Hello, this is Vivian Solomon, and we are going to be taking a stroll through the Oregon Rules of Professional Conduct today. Some sections we might walk through and others maybe more of a run. If you have not seen part one of this presentation, it's available for free on my website, viviansolomon.com, and you can get 1 hour of CLE ethics credit from the Oregon State Bar for watching that program, just like for watching this one today. The Oregon citations, I use those where I can find them. If I cannot find them, I used cases from jurisdictions that also use the ABA model code on which the Oregon cases are decided. There's more about research tips in the first part of this presentation. Some cases cite to the disciplinary rules, and I wanted to let you know there is a handy cross-reference chart at the end of the Oregon Rules of Professional Conduct, the ORPC, that will tell you how to cross-reference the DRs with the ORPC sections. And some of my cases are from, some of the things I'm going to say are from cases that are not in my written materials. If you would like copies of those cases, please email me and I'd be happy to send them to you. And finally, there are some gaps in the rules and the numbering. Those are not mine. The gaps are there left for future expansion. So let's get started with Section 2. Section 2 is counselor. Rule 2.1 is advisor. And there are two basic tenets for this rule: exercising independent professional judgment and giving candid advice. So in providing advice, a lawyer has to think about the client as a whole, cannot just give technical advice. You need to consider the client's emotional condition, financial condition, social condition, and tailor your response and your advice to that particular client. This is based on one of the general rules about lawyers not putting their interest in getting paid ahead of the interests of the client. The next rule applies when a client, most likely a company, would ask you to prepare an evaluation of the client for use by a third person or entity like the SEC or some other governmental entity. If you do this evaluation, it does not make the third party your client. You have no attorney-client relationship with that third party. And also, if you deem this evaluation likely to include material adverse to your client's interests, you need to discuss that with your client and get your client's consent, preferably in writing, to go forward with that project. Lawyers serving as mediator is the Oregon title for Rule 2.4. The ABA model rule applies to mediation and arbitration. So in Oregon, it only applies to mediation, and it specifically does not apply to mediation programs established by operation of law or court order. So it doesn't apply to ORS Chapter 33 mediations. In a private mediator, the lawyer mediator cannot represent either of the parties to the mediation, or any of the parties, must obtain the party's consent to becoming the mediator, may memorialize the mediation agreement, must recommend that all parties obtain independent legal counsel before signing any documents, and the mediator is allowed to file documents with the court. Let's leave the counselor role and go on into lawyer as advocate. The first rule is that you need to have a basis in law and fact for the claims that you advance with the court. Whether you may not knowingly bring or defend an action, assert a proceeding, delay a trial, or take other action on behalf of a client that does not have a basis in law and that is not frivolous. So, for example, this rule was applied where a lawyer challenged without appropriate factual basis a district court's handling of his client's trial, and also where a lawyer presented a fictional bankruptcy petition Seriously? Yes, this happened. Now, if the lawyer has a plausible explanation for his or her assertion, that is not a rule violation. In the ethics rule context, the issue is not whether the lawyer is ultimately correct in his or her opinion, but rather whether the position the attorney took was neither frivolous nor unwarranted. And I cite you to a 2012 Oregon case where the lawyer took a position based on Oregon's tort reform contribution statute, and the final authority, the Supreme Court, decided that it was acceptable. Next is Rule 3.3, candor toward the tribunal. There are multiple sections here. These rules are ongoing. They continue through the end of the proceeding. No knowing false statements. Lawyers may not knowingly make false statements of fact or law to a tribunal or fail to correct a false statement of material fact that was made earlier. Like the case of the look-alike siblings who pretended to be each other and did not want to fess up in court. Doesn't this sound like a Shakespeare plot? Formal Ethics Opinion 2005-53 noted that the lawyer clearly was compelled to call on the client on the stand to tell the truth, and that the lawyer could not ethically assist that client in continuing the fraud. But the odd thing is that it's not an isolated case of people switching in the state of Oregon. In Ray Willie's, in a 2008 decision, involved a defense attorney appearing at a criminal proceeding with a person at counsel table who was not the defendant. And the attorney did not tell anyone until after he had cross-examined the state's witnesses. By presenting the imposter as the defendant, the attorney was deemed to have engaged in fraudulent conduct. So, no knowing false statements. 2, tell the court of adverse controlling legal authority. Even if you don't want to do so, you need to disclose directly adverse legal authority if your opponent has not done so. And in particular, the Ninth Circuit has observed that this rule is very important so that judges are not the victims of lawyers hiding the legal ball. And just in case you can't remember your legal research and writing class in law school, failing to mention directly contrary authority is not a good faith argument for its modification or reversal. That's a quote from an Oregon case. Number 3, don't offer false evidence, and if that happens, take remedial action. So don't misrepresent facts in a declaration that you file with the court. And there are several matters that involved notary problems. So I'll let you know, don't offer into evidence a document that was notarized over the telephone. Don't witness and notarize wills outside the presence of your clients. And don't notarize signatures on pleadings when the affiant is not present. Now, if somehow it has occurred and you have offered false evidence, you must take reasonable remedial measures, including telling the tribunal. But before you tell anyone, you need to remember that you have obligations of confidentiality under Rule 1.6, which does not require the disclosure of certain protected information. So make sure you think about that before you disclose. And if you have a client who insists on offering false testimony, you need to tell that client that you, as a lawyer, have an obligation not to do that, and that if offered, you need to take appropriate remedial action. Number 4, don't conceal evidence. Lawyers have to disclose that which the law requires them to reveal. And so don't attempt to dissuade parties from appearing at depositions, and don't lie for your client. In Ray Miles, an attorney, signed and submitted an affidavit to the administrative law judge in which he made a statement that was untrue in support of his client's claim for unemployment benefits. Now, things are a little different in the criminal context. You may refuse to offer evidence that you reasonably believe is false, except in the case of a criminal defendant who wants to testify to matters that may or may not be false. If you are faced with such a perjury-bent criminal client, you cannot keep that person off the stand, because to do so would violate the client's 6th and 14th Amendment rights, a fundamental right to testify in his or her defense. This is why the model rule includes an exception for criminal cases, because otherwise you'd be in a pretty tight spot. If you offered the false evidence, you could be accused of offering false evidence. And if you didn't allow the client to testify, you could be accused of violating the client's constitutional rights and also providing ineffective assistance of counsel. And finally, don't hide facts at ex parte. I wonder why we need a separate rule for ex parte, but I believe it's because it's not a contested hearing and there's only one lawyer showing up. And also, courts regularly rely on the candor, honesty, and integrity of lawyers in the ex parte context. So let's learn from the reciprocal discipline of Page. Page was a Washington lawyer practicing in Oregon. And this was a domestic relations matter. The parties had agreed on a settlement and had agreed on terms. Opposing counsel and his client had signed the settlement documents and had sent them to Page. She talked about them with her client, who didn't like some of the terms, and at his request, she started changing the terms in the signed agreement. And these were not small changes. She needed to use whiteout to avoid disturbing opposing counsel's signature on one of the pages. She changed the child support arrearage figure by over $1,000. She imposed a requirement that the wife had to notify the husband if the child was moved, if changed residence, and she changed the wording in the final decree about the husband's ability to take the child out of the jurisdiction. And she didn't tell opposing counsel. She just filed it at ex parte. You can imagine this did not go over well. So don't hide things at ex parte. Rule 3.4 is fairness to opposing party and counsel. This is another multi-part rule, starting with you shall not obstruct access to evidence or unlawfully alter, destroy, or conceal a document or other material having evidentiary matter, and you cannot have someone else do this for you. This is a general thread running through the Oregon Rules of Professional Conduct. You cannot have someone else do by proxy what you yourself are not able to do. So this first subsection, the reciprocal discipline of Page case would apply because there was an unlawful altering of a document. Number 2, do not falsify evidence or testimony or have others do so. There's an Oregon case in Ray Leonard, or a DA falsified public records and then lied about them to the public, to the court, to her own staff. And again, that didn't go over well. You cannot offer an inducement to a witness to testify. You cannot pay someone to testify, but you can pay a witness the reasonable cost of attending the trial, including reasonable compensation for loss of time. And of course, you can pay an expert witness that person's fee. Number 3, do not disobey court rules. Pretty self-explanatory, but you are allowed to openly refuse to comply with a rule where you believe no valid obligation exists. D, do not make frivolous discovery requests, and if you receive a request, be diligent and try to find all of the documents that are responsive to those requests. Once you get to trial, do not allude to any matter that you don't think is relevant or that won't be admissible. Don't assert personal knowledge about any fact and issue unless you yourself are testifying, and we'll get to that in a little bit. Don't state anything about the culpability of a civil litigant or the guilt or innocence of a criminal or an accused. F, Do not mention irrelevant, we just talked about that. Do not advise or cause a person to secrete themselves, leave the jurisdiction, or otherwise become unavailable as to be a witness. And finally, don't threaten criminal charges to obtain an advantage in a civil matter unless you reasonably believe the charge to be true, and your reason for bringing this up is to have the person right a wrong, which is the subject of the charge. An Oregon example of how Rule 3.4 has been applied could be subtitled, "Don't play the court and opposing counsel off each other." In Ray Wilson, the attorney falsely represented to opposing counsel that the court had postponed the trial date, and then falsely represented to the court, both orally and in an affidavit, that opposing counsel had withdrawn her objection to the reset. This was a rules violation. Section 3.5, impartiality and decorum of the tribunal. Don't seek to influence judges, jurors, or others. There is an interesting formal ethics opinion 2005-56 where some lawyers had decided to set up a vacation fund for a judge, and the opinion is written in a little bit of a tongue-in-cheek sort of tone, because the author wrote, if the lawyers are not seeking to influence a judge by creating a vacation fund, and don't know that the judge's acceptance of such a fund would violate the rules of judicial conduct, then soliciting and donating the funds does not violate Oregon Rule of Professional Conduct 3.4 and other rules, 3.5 and other rules. What the lawyers intend is a question of fact, but the lawyers should be mindful that bribery is a crime. So judges can receive gifts which are ordinary social hospitality, but probably not a vacation fund. Contact with jurors. Do not contact jurors. There's a 1976 case in Ray R. where a client was on his way home from the courthouse when he picked up a hitchhiker. Neither one of them realized for a little while that the hitchhiker was a juror in the client's case. They were both kind of embarrassed, but they continued on for another 10 or 15 minutes and did not talk about the trial or anything in it. The decision was vacated on other grounds, and the lawyer never reported the conduct, which was a mistake because the Supreme Court said that it is immaterial when the lawyer learned of the juror contact, because when an attorney learns of improper conduct at any time when the court could rectify the issue, the attorney has an obligation to do so. Do not disrupt the tribunal by having a temper tantrum or otherwise acting unprofessionally. And if you know that a jury member or a person in the jury member's family has acted improperly, perhaps by doing some legal research of their own on an issue in the trial, you need to let the court know right away. Trial publicity. This rule has, in this group of rules, one of the most interesting histories, I think. The ABA's first attempt to put a rule on or attorneys' abilities to comment on cases goes back to 1908. And they tried to combat the ill effects of attorney-generated trial publicity. This is an area where there is tension between a lawyer's First Amendment rights and the right to free press, and a defendant, particularly a criminal defendant's constitutional rights under the 6th and 14th Amendments to have a fair trial. Preserving the right to fair trial necessarily curtails the information that can be disseminated by the lawyers. What I think is interesting is that this current rule grew out of the work of the Warren Commission after the assassination of President Kennedy in November 1963. The Warren Commission was concerned with the way the Dallas police had disseminated information and urged the police, the bar, and media to work together to come up with some rules about acceptable trial publicity. The Supreme Court followed that up with two decisions uh, in the 60s. One was that televisions and cameras in the courtroom did not allow for a fair trial, and the other was in Shepard versus Maxwell, where a carnival atmosphere prevailed, and the local paper ran a headline something like, "Somebody got away with murder." This did not set the criminal defendant up for a fair trial. So in 1968, the ABA established a set of rules saying it was the duty of a lawyer to prevent the release of information that is reasonably likely to interfere with the fair trial. In 1983, the ABA was concerned about that language and changed it again. So the current rule that we have attempts to regulate trial publicity in a way that constitutionally balances the lawyer's right to free expression and the accused's right to a fair trial. If you need to know exactly what you can say, I suggest you read the 7 subparts with sub-subparts of this rule. And of course, a lawyer can reply to charges publicly made against him or her, and can also make comments if the lawyer is serving on a legislative, administrative, or other investigative body about or participating in the proceedings of one of those entities. 3.7, lawyer as witness. While we would sometimes like to take the stand and just tell the jury the way it is, we are not allowed to do that. This rule protects the integrity of the judicial process in 3 different ways. It eliminates the possibility that the lawyer will not be an objective witness. It reduces the risk that the finder of fact can confuse the roles of witness and advocate, and it promotes public confidence in a fair judicial system. Now, importantly, this rule applies to the trial lawyer. It does not apply to a lawyer who is assisting the trial lawyer. So if you need to put an assistant on the stand, that's not going to require you to withdraw. But if you have to take the stand, you must withdraw as counsel unless there is substantial hardship. There is an Oregon Formal Ethics Opinion 2005-8, which noted that a lawyer's special skills and a client's emotional makeup were together not enough for the substantial hardship exception to apply. This rule does apply in arbitration as well as in trial. Rule 3.8, we're going to go through pretty quickly. The special responsibilities of a prosecutor. Prosecutors should refrain from prosecuting a charge that they know is not supported by probable cause, and they should make timely disclosures to the defense of all evidence and information that tends to negate the guilt of the accused or mitigate the offense. There is a split of authority on the extent to which this rule is applied, and if that is an issue in one of your cases, I suggest that you read the State ex rel Oklahoma versus Ward case that is cited in the materials. Rule 3.9, advocate in a non-adjudicative proceeding. Don't you just love those 6-syllable words? This applies to appearances in official hearings or meetings of governmental agencies or bodies. It does not apply when representing a client in a non-adjudicative negotiation. Bottom line, if you are representing a client in a non-adjudicative proceeding, you must reveal that your appearance is in a representative capacity, and then you have to comply with the rules we just talked about. You need to act with candor toward the tribunal, fairness toward the opposing party and counsel, and impartiality toward the tribunal. Let's move on to section 4, transactions with persons other than clients. Truthfulness in statements to others. Like your parents told you, rule number 1, don't lie ever to anyone. It does not work out well. This rule tells us that while we are representing a client, we shall not knowingly make a false statement of material fact or law to a third person or fail to disclose a material fact when that disclosure is necessary to avoid assisting in an illegal or fraudulent act by a client. Again, of course, unless that disclosure is prohibited by your confidentiality obligations. The case cited for this was a lawyer who knew that his client was operating a prostitution business, but denied that knowledge to the district court when asked. This rule applies to all aspects of your work, including settlement negotiations. And then I thought I'd just give you a couple of cases from other jurisdictions that have dealt with this. The Florida bar disbarred an attorney who misrepresented to a leasing company the identity of who would be using leased office equipment. The South Carolina bar disbarred an attorney for misrepresenting facts to a title insurance company during negotiations to obtain a title policy. And the California bar sanctioned an attorney who misrepresented to opposing counsel that funds would be deposited in escrow when he actually didn't do that. So don't lie and don't help your clients commit fraud. Section 4.2, communication with persons represented by counsel. Now, have you ever been contacted by someone who is lawyer shopping? They have a lawyer, but they want to see if maybe they can get a different lawyer. Or maybe you've been contacted by someone who claims to be pro se, but they actually have a lawyer. They just, for whatever reason, think that they can handle things on their own. Well, you don't have to worry about talking to them if you reasonably do not know that they are represented. This rule only applies to if you to people you know are represented. So if on the same or similar matters. So when you do know that a party is represented, do not communicate with that party orally or in writing, and don't have someone else like an investigator or a claims agent do it on your behalf. That's not allowed. There are a couple of caveats here. The first is that parties can communicate with each other as long as they were the ones that instigated the communication. It cannot be parties talking to each other because the lawyers suggested that one or both of them do so. And secondly, there are a few statutes in Oregon that require the communication go directly to the party, and those are very narrowly construed. So there are some exceptions where you can communicate with a person represented by counsel because the law tells you you have to do it that way. And what about social media? Well, a 2013 ethics opinion concluded that lawyers may, yes, access publicly available information on social media. They said this is not like a communication. It is more like reading a magazine article or a book authored by your adversary. So what if you are dealing with a truly unrepresented person? Well, you still have to be careful. And the main reason you have to be careful is so that the person doesn't think you are providing legal advice. The only legal advice you can give that person is to go get a lawyer. Otherwise, you need to make sure that they know that your interests are not aligned with their interests, that you are actually representing someone whose interests are most likely opposed to theirs, and you need to make sure not to give legal advice. I think I already said that. So the formal ethics opinion 2005-16 had two different scenarios that I think are worth going through, a civil one and a criminal one. In the civil case, a lawyer represented a client who was in a car accident, and he wanted to talk to the driver or send a letter to the driver of the other car, who he didn't know whether that person was represented or not, saying how terribly injured his client had been and suggesting that the other driver contact his insurance company and have them accept a policy limits demand. This is not okay. There's too much information to give to an unrepresented party with whom your interests are adverse. Similarly, in the criminal context, the fact scenario was a lawyer who knew of a witness that was subpoenaed to testify before a grand jury on issues that were probably related to what the criminal client, what the charges against the client were, and the lawyer wanted to contact that witness to say that it would probably be a good idea for the witness to assert the Fifth Amendment. Again, this is too much information and this is not allowed. What about social media again? You may seek to friend an unrepresented person. Again, as long as you don't try to pretend that you're not disinterested. But the formal ethics opinion says that people are in control of their own social media and they can decide whether or not they want to accept your friend request. Rule 4.4 is respect for the rights of third persons, and then a completely unrelated topic in my mind, inadvertently sent documents. So let's talk about respect for the rights of third persons first. This is basically don't embarrass, delay, or harass third persons or violate their rights just to obtain evidence. The ABA model rule doesn't give much information other than say that this involves or this includes privileged relationships like the attorney-client privilege. You shouldn't try to get information that is privileged in order to advance your case. But the North Carolina State Bar got a little bit more specific and said threats, bullying, harassment, insults, slurs, personal attacks, and unfounded personal accusations generally serve no substantial purpose other than to embarrass, delay, or burden others and violate this rule. So if you needed more information about respecting the rights of third persons, there's a list for you. So now let's switch to inadvertently sent documents. Well, if you know what the term clawback means, this is the ethics rule that goes with that whole concept. A lawyer who receives a document or ESI, electronically stored information, and knows or reasonably should know that the document or ESI was inadvertently sent shall promptly notify the sender. Not return the document, just notify the sender. So what if you are the lawyer who sent the privileged materials by mistake? You might be in trouble because there is a presumption that when a lawyer reveals privileged information, this was done with the consent of the client and with the lawyer's authority. If push comes to shove and you are in this situation, there is an Eagle Crest Partners case which says a fact question arises as to the reasonableness of your actions. So if your actions were reasonable and some privileged material was produced inadvertently, you may be able to get away with not violating this rule. But let's talk about the other side. What if you are on the receiving end of some information that is privileged? The bar has a couple of fact scenarios I thought I would just put up here so that we could go through them together, followed by 5 questions that the bar asks and answers. So the main scenario is that lawyer A mails lawyer B a draft of an agreement that they are negotiating, and using standard word processing documents or standard word processing programs, the recipient was able to see the metadata. Now let's back up for a moment and say, what is metadata? For our purposes, metadata is data about data. It's embedded in the document. It could be information about who created the document, when it was created, if it was altered, when it was altered, and sometimes even comments that are made about the changes. So the receiving lawyer sees this metadata, and that's it. The second scenario is the sending lawyer urgently calling the receiving lawyer and saying, oh my gosh, please don't read that and send it back, or delete it without reading it. And the final scenario is the receiving lawyer using a special metadata thwarting program to access the metadata. So then there are 5 questions. First, does lawyer A have a duty to remove or protect metadata when transmitting documents electronically? The answer is yes. You need to look at rules ORPC 1.1 and 1.6a, which require lawyers to have a general basis of competency in metadata and electronic documents, or to hire someone with that competency to do the work for them. The second question, may the receiving lawyer use metadata that is readily accessible with standard word processing software? The answer is a qualified yes, given that the sending lawyer had a duty to exercise reasonable care not to provide the privileged material. The receiving lawyer could reasonably conclude that the material was in there intentionally. But if the receiving lawyer knows or reasonably should know that the privileged material was inadvertently sent, then the receiving lawyer requires notice to the sender. It does not require return of the document unread or to comply with any other deleting requests by the sending lawyer. Third question, must the receiving lawyer tell the sending lawyer that the document contains readily accessible metadata? The answer is no. That is not the receiving lawyer's job. Fourth question, must the receiving lawyer acquiesce to the sending lawyer's request to delete the document without reading it? That is a qualified no, only because the receiving lawyer should talk to his or her client about the relative risks of reading the document versus returning it. And finally, can the receiving lawyer use a special program to access the metadata? And the answer there is no, that is not ethical. Let's move on to section 5, which has to do with law firms and associations. This section has 3 rules in it that address ethical issues involved in law firms and corporate counsel offices where more than one lawyer works on a case and where a non-lawyer might be assisting the lawyer. So the first rule is 5.1, responsibilities of partners, managers, and supervisory lawyers. You are your brother's keeper, your sister's keeper. You are responsible for your law partner's violation of ethics rules under certain circumstances. And what came to mind was lawyer Matthew Farmer's claims in 2006 that his Holland and Knight partners had padded their firm's bill to the insurance client. And I've given you the Wall Street Journal citation for this because I could not find another place where the resolution was published. But the Mr. Farmer, the whistleblowing lawyer, recalled that on the first day he saw the file, he spent maybe 15 minutes with it, but the bill showed a 6.5-hour charge. So this was not a small amount of padding. Mr. Farmer concluded that he needed to blow the whistle because otherwise he could be culpable with his partner in that kind of billing. The second part of this rule has to do with being a supervisory lawyer, and thou shalt mentor, and thou shalt not overburden thy associates. There's a 2007 Oregon ethics opinion which says if a supervisory lawyer knows that a subordinate lawyer has a workload that prevents him or her from providing competent representation to clients, the supervisory lawyer is responsible for the misconduct of the subordinate if the supervisory lawyer failed to take effective remedial measures. So you need to keep track of how busy your associates are and to make sure that they are able to represent their clients appropriately. What if you are the subordinate lawyer? Just follow the rules. You can't get out of this just because you are a non-supervisory lawyer. And this came up in a Kentucky case where the court refused to dismiss a malpractice claim against the non-supervisory lawyer, saying that everybody has the obligation to follow the rules. And finally, what about non-lawyers that work with you? One thing you should note is that for purposes of this rule, disbarred and suspended lawyers are considered to be non-lawyers. You can hire them to do the work that a law clerk would do. They cannot give legal advice or work as a lawyer. You need to make sure that you know what is going on in your firm. Inside the office, there's an Oklahoma case where the attorney's staff mishandled a client's insurance settlement proceeds, and the court issued a very strong opinion and said a lawyer who fails to properly supervise personnel, particularly with knowledge that the employee is engaging in conduct that would violate the ORPC, is guilty of dereliction. So you don't want to be that lawyer. So make sure you know what's going on inside your office. And outside your office, you may contract with third-party vendors so long as they maintain the same obligations of confidentiality that you have. So for example, you may contract with a third-party vendor to store client files and documents online on a remote server, as long as the vendor is competent and will maintain confidentiality and keep the client documents secure. This formal ethics opinion noted that lawyers handling national security interests may want to take additional security precautions. So for those of you, take note. Section 5.4 has to do with the professional independence of a lawyer. Now, this rule sets out the traditional limitations on sharing fees. The reason for these limitations is to protect the lawyer's professional independence of judgment. With some exceptions that are clearly set out in this rule, lawyers may not share fees with non-lawyers, including lawyers who've been disbarred or are suspended during the period of their suspension. Lawyers cannot form partnerships with non-lawyers if any of the activities involve the practice of law, and lawyers cannot contract with non-lawyers where the practice of law is involved. This came up in a Kentucky case where a doctor agreed with a lawyer that the doctor would be paid a percentage of the attorney fees recovered by the lawyer in exchange for her introduction of the lawyer to her patients who possibly had a claim. Now, while lawyers cannot refer a client to a non-lawyer with the understanding that the lawyer will receive anything of value in return, a lawyer may accept gifts in the ordinary course of hospitality, social or business hospitality. That is allowed. And please note that this rule does not prohibit one lawyer paying another lawyer for a referral, particularly if the referring lawyer continues to be involved in the matter. Here's another rule with two completely distinct parts: unauthorized practice of law and multi-jurisdictional practice. So let's start with the first part. You cannot help your client practice law if your client is not a lawyer. You can assist your lawyer in doing things that the lawyer could, or that the client could do on his or her own as a member of the public, like handling FED actions. But you cannot have your client fill in the blanks and sign your name or do anything else in your name, because a lawyer must supervise and control the work that is done in the lawyer's name. Let's switch to multi-jurisdictional practice. This has exploded in the last 30 years since the United States Supreme Court decided that a lawyer can practice in a state other than where he or she lives. And that has been mirrored by technology and the internet. These have made interstate practice common, and it is just very burdensome for a client with a multi-jurisdictional business to have to hire local counsel in each of the different jurisdictions where the business does business. So Rule 5.5 sets out the ways in which someone non-admitted to the Oregon bar can temporarily practice law here without violating the ethics rules. It sets out the pro hoc vice rules that need to be followed. And I did footnote a bar article that I recommend to you if you are the local counsel who is being asked to prepare pro hoc vice papers, just to make sure that you avoid pitfalls. And I also refer you to a second law or bar journal article about when practicing law in another state stops looking temporary and starts looking permanent. That's a 2007 article, but if that issue comes up for you, it should be a good starting point. Section 5.6, restrictions on rights to practice. There are no non-competition agreements for lawyers. And interestingly, even though this is couched in terms of the lawyer's right to practice, the real reason behind this rule is to make sure that there are enough lawyers to go around for all the clients. It's to ensure the freedom of clients to select the counsel of their choice. So you cannot penalize somebody or make them pay a penalty if they leave your firm and go practice somewhere else. Now, there is an exception for retirement benefits, and as this is not dependent on clients or having choice of counsel, it is allowed, and I call it the you can't have your cake and eat it too rule. You cannot accept money from your law firm while you are in retirement and then come out of retirement and compete with your old law firm, possibly even taking some of your old clients with you while still retaining those retirement benefits. You can have one or the other. So it's perfectly fine to put a provision in a retirement agreement for a lawyer that is a non-compete as a condition to accepting those benefits. Section 6 has to do with public service. This section encourages lawyers to engage in legal public service without too much concern about violating conflict of interest ethics rules. As you may recall from my presentation last year, there is another thread that runs through the rules of ethics that encourages pro bono service. So the first rule in this section is membership in legal services organizations. This rule was adopted partly because there aren't enough people doing providing legal services for indigent clients. This rule allows you to be a director or an officer or a member of a legal services organization, even if it serves people having interests adverse to those of you or your law firm. Now there is a caveat. They haven't done away with the conflict rules altogether. You may not participate in a decision or an action if you know that this is incompatible with your conflict of interest rules, or where that decision or action could have a material adverse effect on the representation of a client of the organization whose interests are adverse to yours. Rule 6.4, law reform activities affecting client interests. Now, law reform activities include things like writing rules, restatements, and so on. You may serve as a director or officer or member of an organization involved in law reform, even if that reform may affect the interest of a client. If there is a potential conflict of interest, you have to disclose the fact, but you don't have to disclose the client. So if you think about this practically, we want people who work in a particular area, let's say antitrust, to be drafting the rules for other people who have antitrust matters. But it's not fair if you represent a client who can benefit from a particular wording of an antitrust statement. So you need to disclose that to the organization so that everybody can take what you say with a grain of salt. Otherwise, it's encouraged. The next section has to do with nonprofit and court-annexed limited legal services programs, and limited is the key word here. These are low-income legal clinics, legal advice hotlines, advice-only clinics, and pro se counseling programs, and similar limited programs. They are normally operated under circumstances in which it's not feasible for the lawyer to systematically check the lawyer's conflict system, as it's generally required when we take on a new client. So because of the limited nature of this representation, the risk is deemed to be lower that there will be a conflict, and the imputation of conflicts of interest and screening is generally inapplicable. So this means that unless you know for sure that there is somebody who is adverse to your firm, like let's say your firm represents a railroad, you should not be counseling an injured railroad employee on his or her FELA rights against the railroad. But if you don't have a reason to suspect that there is some kind of conflict, um, your participation will not preclude your firm from continuing to represent an adverse client. And your contact with the adverse low income or hotline client is not imputed to the firm. So the firm as a unit rule doesn't apply. You can't be involved, but it doesn't disqualify your law firm. Now, this rule changes if the word limited is dropped and you take on the person as a client. In that case, you need to do all of the usual conflict screening that is required of lawyers. Moving on to Section 7, communication or information about legal services, Section 7.1, communication concerning a lawyer's services. This is a variation on don't lie. Don't advertise or tell others that you are more than you are. For example, if you are a part-time lawyer, excuse me, if you are a part-time judge, you cannot have your office staff answer the phone saying Judge so-and-so's office. But if things are true, then certainly communicate them. You can use the name of a lawyer who is no longer with your firm because he or she has retired from the active practice of law, so long as that does not create confusion. If it does create confusion, you cannot use that name. If you are an Oregon law firm that contracts with a Washington firm, you may put the Washington firm on your letterhead as an associated office, because that's true. So don't lie about what you can do, and don't lie about who's in your firm. And let's talk about advertising. Lawyers didn't used to advertise at all. It was prohibited. And now we have giant billboards and late night TV ads, and most of those are fine. Advertising is an exception to the prohibition against paying for referrals. So, for example, there was a case in Connecticut where a lawyer was paying $50 to employees for client referrals. That's not ethical, but the lawyer could pay that same $50 toward advertising to people that he doesn't know, and that would be okay. So this rule also prohibits quid pro quo arrangements. Like you can't say, I will send you, title company or other non-lawyer, clients in exchange for you, title company or other non-lawyer, sending them back to me if they need help. That is not okay. That's not appropriate. If you do advertise, you need to include the name and office address of at least one person in the law firm who is responsible for the content of the advertising. And be wary of cross-jurisdiction marketing. In a useful article, Oregon lawyer Mark Fusile writes that those of us here in Northern Oregon may also practice in Southern Washington. And while Oregon allows you to say that you are a specialist, as long as that's true, Washington generally does not. So you want to make sure that your advertising complies with all of the rules in all the states where it's going to be going. Let's talk about solicitation of clients. I've alluded to this a little bit already. There's a difference between solicitation of clients and sending out required notices, but this is a very, very fine line. I cite you to a California case involving the Private Securities Litigation Reform Act, which requires notices to be sent out, and there was a law firm that sent notices to brokers and dealers containing information about the pendency of a case and basically saying they were available if necessary, and the court found that because of the Act's requirements, that was not solicitation. But other than that narrow exception, you may not make cold calls to solicit clients, with an exception that you can call people who are lawyers, you can solicit people who are family members or close personal friends or who have had a prior professional relationship with you. But then there's an exception to the exception, which I call the don't be a jerk exception. You cannot cold call anyone if you think that the person does not have the physical, emotional, or mental state to be able to make a decision about whether to be represented. You can't cold call people who have asked you not to call them, and you cannot solicit clients if the solicitation involves duress or harassment. So just don't be a jerk, you'll be fine. Lawyers are allowed to send greeting cards, and they're allowed to send thank you letters to their current and former clients, thanking them for having used their services. Lawyers can also hold open houses, even though it's possible that some um, improper in-person solicitation might occur there. As long as that is not the main reason for the open house, you go ahead and send out your open house invitations. Now, if you do solicit professional employment in writing, you must include the words advertising material on the outside of the envelope. And if it's an electronic communication, you need to put advertising material at the beginning and the end of that communication. You don't have to do that if you are soliciting professional employment in writing with a friend, a lawyer, a family member, or someone who has done business with you in the past. And finally, there is an exception to this rule for prepaid or group legal service plans. Lawyers can participate in those organizations even though they use in-person and telephone contact to solicit memberships from persons who are not necessarily known to need legal services. Next is firm names and letterhead. You all remember Click and Clack the Tappet brothers and Dewey, Cheatham, and Howe. But back to the rules. You just need to not misrepresent what is going on. The purpose of this rule is to protect the public by prohibiting the use by lawyers of names which would mislead non-lawyers concerning the identity, the responsibility, or the status of those who use such names. So, for example, you're not of counsel, you are not associates, or of counsel for that matter, if you are just office sharing. It's misleading to say otherwise because it implies that you practice in a partnership, and you really don't. Now, similarly, for those lawyers who are employed by an insurance company and all they do is defend the insured's liability claims for the insurer, they have to say that they are employees of the insurer. You can use a trade name as long as it does not imply a connection with a government agency or some public or charitable legal services organization. And also, using superlatives in a trade name is looked down on. I cite you to a case where the name in question was the Alpha Center for Divorce Mediation, and the court went through quite some analysis to conclude that the only reason Alpha was there was to indicate superiority and primacy, and therefore it was a superlative which was not allowed. Now, on the other hand, if you are in Portland, Oregon, and you practice in the Hollywood district, it's perfectly okay to say that you work at the Hollywood Law Office. Let's talk about multi-jurisdictional practice again. The firm obviously can use the same name nationwide, but the firm has to identify which lawyers work in which offices, which lawyers are licensed to work in which states. So there's no confusion that all the lawyers are licensed in all the states where the law firm does business. Finally, of counsel, when can you really use of counsel on a letterhead? That is reserved for a relationship between a lawyer and a law firm when the lawyer is neither a partner nor an associate, but has a different kind of ongoing relationship. Similarly, general counsel falls in that category. You can use the term general counsel on your letterhead and otherwise, as long as you do a substantial amount of work for that client, a substantial amount of professional time representing that client. Let's go on to Section 8, maintaining the integrity of the profession. This first one is pretty quick, bar admission and disciplinary matters. If you are applying for the bar, don't lie on your application, don't omit things, and make sure that you actually have gone to law school before you bother applying. If you are already a lawyer and the bar calls you and asks for information, you need to respond completely, thoroughly, and promptly. Failure to do so is a violation of Rule 8.1 of the ORPC. Judicial and legal officials, this is another quick one. It allows lawyers to campaign for judicial office. And then I guess they had to put this somewhere, but you are not allowed to slander judges and judge candidates. And some of us might wonder, well, why do we need this rule? Well, it's because somebody has done that. At least one person. I cite you to a Minnesota case where the lawyer was going around saying that the judge was participating in a conspiracy to rig the outcome of his case. Rule 8.3 is touchy, reporting professional misconduct. It's mandatory. If you know that somebody is violating the rules of professional conduct, you must report it. This is part of maintaining the integrity of the profession, part of maintaining the public's view of us as some people who are trustworthy. Speaking of which, the reporting is required if the act in question affects the lawyer's honesty, trustworthiness, or fitness as a lawyer. We'll be talking about those three things in a little bit. Might help you figure out when you have to report. Obviously, you don't have to report if you are working for the State Lawyer Assistance Committee, the PLF, or PLF Loss Prevention Program, or other entity as bar service where you are seeing people and hearing about people who have engaged in professional misconduct. So let's talk about what is misconduct. Well, the first rule is that violating the Oregon rules of professional conduct is misconduct, which itself is a violation of the Oregon rules. How many people here are parents? A lot of what you're about to hear makes me think of my kids when they were really little, and you just kind of roll your eyes and you think, they really thought they were going to get away with this? And other cases that I researched were more like watching a train wreck in slow motion, and I am reporting, not judging, and I know that these lawyers were operating under a great deal of stress and sometimes, but it really seems a bit voyeuristic to be looking into what were clearly intended to be private acts. But I guess it's good that you are reviewing the ethics rules with me here today, because after you reviewed these, there should be pretty obvious where that really big yellow line is about what is right and what is wrong. So there are seven types of misconduct spelled out in this rule. An example of violating the ORPC that's cited in your material is don't seek duplicate damages if you're not sure which of two accidents caused your client's damage and you've already collected for one. Collecting a second time is not trustworthy, potentially fraudulent. Do not commit a crime or engage in conduct reflecting adversely on your honesty, trustworthiness, or fitness as a lawyer. So, for example, do not take bribes to lobby on behalf of your client, and do not engage in crimes of moral turpitude. I include this because I think it's interesting that we still use a definition from 1896. In addition to the crime being knowingly or intentionally committed, it must be an act of baseness, vileness, or depravity in the private or social duties which a man owes to his fellow man or to society in general, contrary to the accepted and customary rule of right and duty between man and man. So, as far as I know, that's still the moral turpitude definition in Oregon. Moving on, criminal conduct must show that you lack the characteristics of trustworthiness and integrity that are essential to the practice of law. I cite you to a case where a treasurer for an alumni association was taking money for his personal use, and the court found that this breach of fiduciary duties to the association called into question the attorney's trustworthiness in handling money. I also cite you to a case where the managing shareholder of a company was skimming. He was theft by deception. taking unauthorized shareholder distributions, using firm funds to pay for personal expenses, and using the firm's credit card and line of credit to pay personal expenses. That is a crime which is misconduct because it violates maintaining the integrity of the profession. Don't shoplift. That reflects adversely on your honesty. And no exchanging sex for legal services, because prostitution is a crime. Let's move on to conduct involving dishonesty, fraud, deceit, or misrepresentation. This conduct does not need to involve the practice of law. In Ray Carpenter involved an attorney who represented himself in online messaging as a local high school student who had engaged in sexual conduct with students. This is not okay. But it doesn't have to be sorted. There's another case I cite where a lawyer executed a promissory note as a representative of a corporation when he knew he actually had no authority to act on behalf of the corporation. Let's move on to dishonesty. Dishonesty is evidencing a disposition to lie, cheat, or defraud, as well as a lack of trustworthiness or integrity. There's a knowledge and an intent requirement for dishonesty to be pinned on you as a violation of Rule 8.4. But a couple of examples: claiming ownership of client accounts is dishonest, as is cashing a retainer check and spending it before you have earned it. How about misrepresentation? Well, to violate this rule, the misrepresentations have to be knowing, false, and material, in the sense that they would or could significantly influence the hearer's decision-making process. So it's not what you think you said, it's what the other person could likely hear. So, for example, misrepresenting yourself as a notary who is able to administer oaths for a deposition is a misrepresentation that other people would likely say, yeah, sure, go ahead, swear in my witness. You cannot leave anyone with a false impression caused by an unintentional misstatement. So, for example, if you leave someone with the impression that a tenant's money is being held in trust when actually it's not, you need to correct that. And also, if you make someone think that you are the personal representative of the estate and let them walk away thinking that, when you know you could have said, I'm not the personal representative, you need to make that correction. If it happens that the lawyer receives a direct financial gain from a misrepresentation, that is treated more severely than if money is not involved. And I cite you to a case where a lawyer enrolled as a student in a community college course that he was teaching so he could qualify for VA benefits. He was suspended for a while for having done that. Engaging in conduct prejudicial to the administration of justice. This is wrongful conduct with the potential to cause harm either to the proceeding itself or to the substantial interest of a party to that proceeding. So, for example, In re Clausen was a lawyer who failed to advise the bankruptcy court that he had a connection to a creditor. That would affect the way things happened in bankruptcy court in that case. And in the conduct of Morris, the lawyer directed her legal assistant to alter a financial account that had already been signed and notarized, and then filed that with the probate court. So this was a lawyer who acted by proxy and had a legal assistant do something the lawyer was not able to do. Also, showing up in court impaired by drugs or alcohol is not acceptable. I cite you to a case where an attorney was so impaired the judge was distracted from the substance of the proceedings. His condition required a delay in the proceedings, and created the potential and the risk for ineffective assistance of counsel. Next, stating or implying that you can influence government agencies or officials is misconduct. There's a lovely, lovely part-time county attorney in Kansas. He had a private practice on the side. Apparently, he missed a deadline, and he threatened to file felony criminal charges against the defendant if the defendant did not withdraw his motion having to do with the default judgment. So that's not okay. Knowingly assisting a judge in conduct that violates the ORPC. One example of that could be making a loan to a judge before whom you appear, or maybe set up a vacation fund. Finally, intimidating or harassing someone because of their status. This paragraph is not in the ABA Model Code, but it reflects the language in comment 3 of the code, which says that discrimination and harassment by lawyers in violation of this paragraph undermines confidence in the legal profession and the legal system. Such discrimination includes harmful verbal or physical conduct that manifests bias or prejudice toward others. It includes sexual harassment or derogatory or demeaning verbal or physical conduct, sexual advances, requests for sexual favors, and other unwelcome verbal or physical conduct of a sexual nature. The substantive law of the jurisdiction on anti-discrimination and anti-harassment can also be looked at to determine what is status-based intimidation or harassment. Rule 8.5 is a quick one. If you are an Oregon lawyer, the Oregon Rules of Professional Conduct apply to you and your actions. And finally, this is a rule because they needed a place to put something about the bar being allowed to write advisory opinions on questions under the rules. This also provides that the written opinions must be made available to lawyers. And then the second part is that in considering alleged violations of the rules, the disciplinary board and the Oregon Supreme Court can take into consideration a lawyer's good faith effort to comply with an opinion issued under the first section of this rule. So with that, I want to thank you for sitting through an hour of Oregon ethics rules, and we have now reached the end of the presentation, and you are entitled to seek 1 hour of ethics credit from the Oregon State Bar. Thank you very much.